The broadcast is now starting. All attendees
Hello
are
and
in
welcome to our
listen-only
monthly
mode.
webinar series from the Micklin Law Group, law firm empowering men in divorce and family law issues. Today's webinar is 8 financial must-dos for divorcing men, tips for securing your future. Unlock the path to financial empowerment amidst divorce with these essential tips from divorce attorney Brad Micklin. This webinar will guide divorcing men through 8 crucial steps to safeguard assets and build a stable financial future. Before we begin, let me introduce myself. This is me. I'm Brad Micklin. I'm the lead attorney and managing member of the Micklin Law Group. We are a law firm concentrated in empowering men and fathers in divorce, custody, and family law matters, with offices in Nutley, Montclair, and Saddlebrook, New Jersey. You'll see on the screen a QR code. You can open your camera app, and that should bring you to my appointment calendar if you want to schedule a consultation to discuss this or any other legal matter. Right, so let's jump into understanding your financial situation. First, take a comprehensive review. Thoroughly review your income, asset, debts, and expenses to gain a complete understanding of your financial standing. Excuse me. This will include many other documents depending on the assets that you have. If you have real estate or even had real estate, go back and find the closing statements for your assets and your debts. Look for current account balances for now and account balances from the beginning of your marriage if they go back that far. You want to look at bank, credit card, mortgage, and retirement statements for that time period. Again, both before and during the marriage. 2, identify hidden assets. By vigilant in uncovering any hidden or undisclosed assets that may be a part of the marital estate. This can be challenging. Usually, I find that in most divorces I handle, one spouse handles primarily all of the finances, and he or she has access to all of the information. But that doesn't mean you can't uncover hidden assets. First, the best place to go are tax returns, or is tax returns. Go through several past tax returns. Look not only at the income statements, but the capital gains, profit and loss, or not profit and loss, capital gains, taxable interest, and any other schedule that appears in any other tax returns. That will usually pick up a good deal of assets, past and present. You may also want to reach out to your accountant and get other tax returns that you may not have. Find out if there are any kind of business or corporate tax returns that may be separate and apart from your personal income taxes. You can look at the mail that you see coming into the house. I don't recommend opening it if it's not in your name. It's a federal offense. But at least you'll see where it's coming from. You'll have a better sense of where assets may be held. And 3, seek professional guidance. Consult with financial and legal experts to ensure you have an accurate picture of your finances. And this you should be doing as early as possible. And I don't say that because I am a lawyer. But you don't want to start the process, get in the mix of the battling and the paper exchange and the research, and then be speaking with an accountant or an attorney. Do that as one of the first things on your list. Prioritize asset protection. First, secure assets. You want to safeguard your bank accounts, retirement accounts, and any other valuable assets to prevent unauthorized access or depletion. This is crucial, obviously, if you have joint accounts. Even if you have accounts in your own name, sometimes the spouse may have access to it. And while most attempts to transfer assets outside of the divorce court jurisdiction are not successful, or at least get equalized by another asset, that's not always the case. Don't always trust that if you have X dollars in a bank account, that if that disappears, that you'll get more money out of the house or some other asset. One, there's obviously tax consequences to different assets, so you may not be able to go dollar for dollar. There may not be as much assets as you feel exist when it comes time for distribution. And the court doesn't always right the wrong. So just because somebody did something wrong and took all the money doesn't necessarily mean they're punished. Now, when it comes to taking your own half, for those that are on the opposing side of this, first, it's going to depend on obviously many other factors. The source of the funds, whether premarital funds, the access and control, who's deposited and how much. But my general advice to people is if there are accounts and you're concerned about depletion, do one of two things. Take one half of the assets, so that is likely to be your equitable share. Or if you're going to take all the assets, deposit it into an account that is clearly identified. It can be in just your name, but that you can identify the source of funds. Make a note, if you start taking assets out, the other spouse will either start doing the same thing or will react much more quickly and acrimoniously in your divorce. So you have to weigh that against the potential benefits. Secondly, review insurance. Evaluate your life, health, and disability insurance policies to ensure adequate coverage during and after the divorce process. This goes from any other divorce or any other insurance that you may have. If you have renter's insurance, if you have car insurance, you want to review all these, not just to know what's in place and to actually you should start shopping for replacement policies, but also in a divorce, you're going to be required to file an affidavit of insurance. This affidavit will require that you set forth all of the insurance policies and policy numbers and certify that you will not change them absent a court order. It also has you certify that you have not changed any policies within the past 90 days. This is very important when you get your adversary's affidavit of insurance, which is generally attached to the initial pleading, which is either the complaint from the plaintiff or the answer from the defendant. And look to see if they're disclosed any insurances that have been transferred or closed in the last 90 days. Lastly, establish your own credit. Take steps to build or improve your individual credit score to secure favorable terms for loans and other financial products. You may find after your divorce that you need more credit cards. You may need a mortgage to buy another house. You may be getting a car because yours were sold during the divorce or your spouse got one. You don't want to wait until that time to find out that there's a credit blemish on your account. Many banks offer free access to your credit reports. There are many credit protection services that will give you a free credit report and monitor your credit. And I say these services because there is still that small effect that you can have on your credit card if you start obtaining your own credit reports or looking into your credit. Sometimes the inquiry itself becomes a blemish, and you want to avoid that minimal risk, as small as it may be. Manage cash flow strategically. Create a detailed budget to track your income and expenses, allowing you to make informed financial decisions. Develop a plan to pay off outstanding debts, prioritizing high interest obligations to improve your financial standing. Allocate funds towards savings and strategic investments to build long-term financial security. First, you have to look at your budget, current and anticipated after your divorce. May require a little tightening of your budget right now. If you are the spouse that is going to be likely paying spousal support or alimony, it's another reason you want to tighten the budget now, so you reduce the spending, reduce the appearance of a large marital lifestyle. You can download this information into Excel spreadsheets. You can probably even upload that into some of the current AI programs like ChatGPT, Copilot from Microsoft. I couldn't remember the name. And they may be able to give you an analysis of where your spending is, where it's high, where it's low. If it happens to be sophisticated, it might not be easy for you to determine at first glance. But you want to understand where you are and where you're going to be going. Secure your income stream. First, employment strategies. Explore opportunities to increase your earning potential, such as pursuing a promotion, changing jobs, or starting a side business. Now, keep in mind that last one is obviously very risky if you're in or going to be going through a divorce soon. One issue that comes up often in my cases is somebody has a good job opportunity. They're concerned how it will impact their alimony obligations. Either they're paying and earning more, has them concerned they're going to pay more. They're earning less, and they're afraid they're going to get less if they earn more. All these are true concerns. My general advice to people is never pass up a good opportunity. It's not likely to impact your alimony dollar for dollar, so you still come out ahead of the game. And while the issues that I mentioned that get impacted by getting a job if you're paying or receiving alimony are only one of 13 or 14 other factors the court has to consider in alimony, so it's not a guaranteed impact. So do what's best for you in the short term because the opportunity may not arise. Alimony negotiations. Understand your rights and negotiate alimony terms that ensure a fair and sustainable financial outcome. I have many websites or many videos on my YouTube channel, which is probably where you're watching this, or my website also has both. I'd recommend you watch how alimony is calculated. I have a webinar on the different types of alimony. It's also important to know. And I have several others that talk about alimony. I recommend you see this because I can't go into a full comprehensive discussion of your alimony obligations. But you want to understand the criteria for alimony. Everybody thinks, well, after a certain amount of years you're paying, or after a certain amount of dollars you pay. It's not that simple. Even lawyers and judges often try to make it that simple or think it's that simple, and it's not. The reason why people make it that simple is because doing it the right way is difficult, so they don't. I recommend strongly understanding the alimony laws, understanding the tax impact to alimony, both state and federal, as well as payments, and the types of alimony. So you're fully aware of the obligations that you're either making or receiving. Another issue I see often with many successful men, and I just say successful men because my practice is concentrated in men's and fathers' rights. It's not a gender bias. It's just historically the basis of my client base has usually been predominantly men, and they have been predominantly the higher wage earners, therefore the alimony payors. And they have a belief that they can handle it. You know, they've had hard times, they've made good money, they're going to make money, they can handle it, they just want to get this over with. They often aren't contemplating changes in circumstances, such as changes in the economy, changes in their health, disability, market conditions. All of these are unforeseeable changes. COVID, I think, opened our eyes to this possibility significantly. But as we get past that time frame, the old mentalities are coming back of, well, I can handle this. You may not be able to handle it. You want to make sure you have good advice and planning, and you've considered everything that may, as much as possible, anything that may happen in your future. Child support considerations. Factor in child support obligations to ensure you can meet your financial responsibilities while maintaining financial stability. Again, I have a lot of YouTube webinars and on my website how to calculate child support, what's contained or what to put in and what not to put in a case information statement. Very important document both for child support and alimony. But again, the mentality is often I'm going to provide for my children, I'll pay more for my children, I'm going to make sure my children are protected, and that's all well and good, and I'm in favor of that. But don't make it a mandatory obligation. Make your child support obligation as minimal as possible. You can and should always give more, but you want to be able to give more. You don't want to have an obligation that's so high that you can't meet it or you can't do anything extra. I always tell my clients you want to be able to take your kids to Disneyland. So agree to pay for extracurriculars at a minimal level, for instance, and then you can contribute more. And when you do contribute more, always make sure the payment is noted as child support. That way, if you give an extra $100 for a school trip and you call it child support, if you later find yourself unemployed and you're behind in child support, you will have paid advanced payments for these monies and get credit when you need it. Lastly, on this topic, retirement planning. Protect your retirement savings and develop a comprehensive plan to ensure a secure financial future. Retirement planning is challenging for a lot of people. Many are relying on their company's programs. Many in the back of their mind might be relying on Social Security. Many spouses are relying on getting their spouses Social Security at retirement. Who knows if those programs are going to be around? But you want to consider retirement planning, regardless of your age, in the midst of your divorce, because you may have a long-term alimony obligation. You may have an even longer child support obligation. There may be college in your future. These obligations are going to creep up, and they're going to displace any potential retirement planning, especially if you haven't put a plan into place. You're much more likely to properly save for retirement if you plan for it in your divorce. It may force you to minimize or reduce payments you were planning to make in either obligations like alimony or child support, but so be it. If you want to be there for your family, you have to be able to live a good life, and this means even in retirement. Separate finances diligently. First, classify assets. Clearly identify and categorize marital assets, separate property, and jointly owned assets to facilitate a fair distribution. Distribution in New Jersey is under equitable distribution, which means it's not necessarily equal, but what's supposed to be fair. The most important thing to realize, and again, I have a YouTube video that goes into this in great detail, is the different types of assets and how assets change their classification in your marriage. So there are premarital and marital. There are active and passive. I'm not going to go into the distinction between those. Again, it's a little more in depth than this calls for. But it's important to know that one asset is not always just one, and it doesn't always remain the same. So a premarital asset can have a post-marital or a marital component, like a home. You buy a home before you're married, you move into it while you're married, and you live there and you raise your family. It will have both a premarital and a marital component. You need to be able to understand and separate those values. 2, negotiate settlements. Engage in open and transparent negotiations to reach a mutually beneficial settlement that protects your financial interests. I know quite often people want to either minimize or maximize their payment or their receipt, depending on which side you're on. And I understand that it's human nature, and I'm in favor of that. But you want to be mindful of the long-term costs. First, if you have 2 lawyers involved at what could be $600, $700, $800 an hour, make sure you're fighting over a sizable amount of money that makes sense. I often tell my clients I'd rather you pay the opponent than me if it's going to get you past this. It's often a better decision, and it's a guaranteed decision. Also, keep in mind, your discussions in settlement are confidential largely. And I say that because I have a difference of opinion than many on settlement discussions, but that I won't go into here either. If you happen to consult or retain me in the future, I'd be more than happy to share that view with you. But your conversations are going to be confidential. So the fact that you offered a lot can't count against you. The fact that you offered a little can't count against you. It can also be used to try to get that amount ordered by a judge. So do what you think is best for the purpose of settlement conferences, and you can do whatever you want from your positions. You can change them however you want once the settlement is over, if you're then going to litigate the matter. Number 3, review legal documents. Carefully review all legal documents to ensure they accurately reflect the agreed upon financial terms of a divorce. So in a divorce, you're likely to have many different documents get executed. During your divorce, you may have consent orders. After your divorce or at the settlement of your divorce, you will have a marital settlement agreement or a property settlement agreement or a judgment of divorce with attached terms. You may go to mediation and make agreements. No agreement in New Jersey as of this date which is essentially June of 2024. No agreement is binding unless it is signed by both parties. So you could spend 12 hours or weeks in mediation, come to an agreement. Often this is done virtually now. Sign off, go home, think it's all done, celebrate, and the other person changes their mind, and you start back from zero. Now that cuts both ways and inures to everybody, to both benefits. You can go home and second guess yourself and decide you don't want what you just agreed to, and you can pull it off the table. Not that I'm encouraging this in any way, I'm just letting you know your options. There's pros and cons to both sides of that, but the important thing to take from this webinar is that no agreement in a New Jersey divorce is binding until it's signed by both parties. Additionally, I think you should look at your legal documents in respect to your estate plan. When you file for a divorce, your wills are revoked by operation of law, which essentially means they no longer exist. And that also means you don't have a will. And if you're getting divorced, you'd want to draft a new will anyway. Make sure to do that right away. You can do that in the beginning of your process. Even if you're still lawfully married, you can indicate that you're doing this subject to your divorce. You could do one and then revise it after your divorce. You can do many things, but you should do something. That's the point to take from this page. Establishing financial independence. Open individual accounts. Open your own bank accounts, credit cards, investment accounts, and build your independent financial identity. This goes in part to the point where I said about changing or taking assets out. You do want to have your own independence. Again, as I said earlier, you may need loans to establish your new life. You're going to need places to put, hopefully, the assets and monies that you're going to take from your divorce. And future concerns, living, raising your children, and retiring, all start today. So don't wait and think you can plan this after your divorce. You're going to have many things to do after your divorce. You're also going to want to be done with all the documents and the lawyers and the planners and the CPAs. So do this while your divorce is pending. Monitor your credit. Regularly check your credit report and take steps to maintain or improve the credit score. We talked about this a moment ago in a different context. But I did mention the monitoring services. So don't just look at it for the purpose of building it. You want to monitor it, not just to make sure that it's safe and secure, but that nothing is going unpaid. A lot of people don't know when mortgages are not being paid. A lot of spouses don't know what debts they have because, as I said, primarily one spouse controls all the finances. So you want to make sure that your credit isn't being damaged during the divorce process because bills may be neglected or unknown. Build an emergency fund. Establish a personal emergency fund to provide a financial safety net in the event of unexpected expenses. There's nothing wrong with this. I'm not telling you to take cash and throw it under the mattress. It goes back to what I was saying about splitting the accounts and transferring them into your own names. Nothing wrong with putting money aside for a rainy day. Again, you're going to have a costly process if you have lawyers and experts involved. You may have spousal support or child support or college, retirement planning. All of the issues that we've talked about thus far in this webinar require you to be financially stable. Well, circumstances change, as I've said a few times, and you need to be prepared for those changes. Emergency fund is one of the best first steps to ensuring that. Plan for the future. Develop a comprehensive financial plan that includes retirement savings, investment strategies, and long-term goals. This is kind of a wraparound to many of the things we've been saying about planning for your retirement, your estate plan, your safety net. All is for your long-term goals. Don't ignore that when you get stuck in the mundane day-to-day of your divorce and it takes your attention away from these very important issues. Seek professional guidance. Financial advisor. Obtain guidance on asset management, investment strategies, and long-term financial planning. You also want to learn about taxable consequences of your sale of assets and the transfer of assets. You want to understand the consequences to alimony, both in the state and federal. Be careful because a lot of lawyers don't know this, the difference between state and federal, or they ignore it by accident. And your financial goals. A divorce attorney. Collaborate with a qualified divorce attorney to ensure your rights are protected and your financial interests are secured. And lastly, the most important, tax specialist, because a financial advisor and a tax specialist may be different. Usually they are. Consult with a tax professional and understand the tax implications of your divorce settlement and minimizing your tax burden. So I guess I actually misspoke when I spoke originally of financial advisor. I spoke more of your tax concerns. So hopefully you weren't reading that closely and you're listening more intently and you got the difference. But either way, you need all three of these advisors. Most of them will consult for free. If you need help ongoing or through the process, obviously most will have fees attached. The financial advisors sometimes work based on the assets in your account. But nonetheless, speak to all three types, speak to as many of them as you can, and certainly secure their assistance. So I hope this information has helped you. Here is how you can contact us if you would like to get a little more information. Again, my name is Brad M. Micklin, and the managing member of the Micklin Law Group. We can be reached at 973-562-0100. My YouTube page is Brad Michael Micklin, and my website is www.Micklin Law Group, which is MICKLIN, MicklinLawGroup.com. You will have an intake process. If you're watching this on YouTube, you can leave a comment or a question. I do review them myself. I do respond to them myself. I have to admit, I may not be that prompt because I don't always review my YouTube comments and I don't get any kind of notification, but I do answer them usually within the week or so. I used to say email me, but quite honestly, I don't always know if I can answer emails because it's hard to give one-to-one advice in an email with such limited information. So I don't usually recommend that as a good option. But when you call my office, my intake will get you scheduled for a meeting and we can answer any questions that you have. Also, if you're watching this, like I said, on social media, please give a like and share it. That does help others get the information. It gets shown and shared a lot more. It will also help my content come up for people that are looking for it. Here is a link to my actual channel. Since sometimes it's a little easier to spell my name, I don't know if you can copy and paste it on the website or on a YouTube video, but you certainly can write it down if you're not able to find it on your own. Legal disclaimers for information. I'll summarize this and leave it on the screen for you to read. The purpose is to say that I am not consulting as your attorney. This is not legal advice. You cannot and should not rely upon it. We do not create an attorney-client relationship. By providing you this information is for advertising purposes only. Nonetheless, I hope it helps you. Thank you and goodbye.